Hi, everyone. Welcome to the stage. We are excited to hear from you. So this is called the tragedy of the Creative Commons, and we're talking about IP and the intersection of IP with DAOs, and I presume it will end up touching on NFTs too.
Always
inevitably.
does.
Always does. So why don't we start with introductions? We'd love to hear a bit about you and your background so everyone has context for your thoughts.
All right. I'm Mike Waves. I'm an attorney. I've been a technology lawyer this is the beginning of my second decade. I've been a lawyer for 10 years, technology attorney the entire time, started as an IP litigator. Then I started doing transactional work. So technology transactions, IP licensing, M&A deals, where the main thing that the company was trying to buy was the technology. Got into Web3 as an attorney 18-ish months ago, joined LexDAO. Been working with those guys. Jordan Teague was just up here a little while ago. You may have seen Ross Campbell's talk. And now I'm joining Alliance as their general counsel soon, I think like 2 weeks. So I'll be working on a lot of these issues firsthand.
And what is Alliance? Just so people have that
Alliance is a Web3 accelerator.
Great.
Hi, I'm Kyle Smith. I spent some time in corporate music publishing and then moved on to law school where I got my JD, but the whole time I was focusing on entertainment law and that kind of thing. And then after that, I went into my own version of smart contracts, which is JavaScript and more about being verbose and contracts being living documents than about Solidity. But these days I'm learning how to write Solidity as well in LexDAO. I'm also in LexDAO. And I'm working with Gitcoin as well. I've got my own project called CheerBot, and it takes Raspberry Pis and connects them to Web3. And then I'm also working with Creative Commons on AI issues. I developed a type of geometry that I had to collaborate with Wolfram's AI in. So yeah, that's how I help Creative Commons, is talk to them about how AI is going to impact copyright law.
Wow, the rare developer lawyer. Someone loves logic. And I'll give you just a little bit of personal background. So I'm not a lawyer. So anything they say you should not take as legal advice or do so at your own caution. Anything I say, you're welcome to take as legal advice, but I wouldn't recommend it. So I am not a lawyer. I run an exchange group for DeFi called Shipyard Software. We develop DEXs, namely Clipper.exchange is a DEX for retail trades. But I have a little bit of a background in NFTs and the IP associated with that, because in 2018, I created an early NFT protocol called Codex, which was about provenance and NFTizing IP for art and collectibles, especially sold at auction. And for that, I did an online art marketplace. So I've come at it from the art industry. So with that, why don't we start with a brief question, which is very high level, which is, how is IP even relevant to DAOs?
I mean, to me, well, especially working with Gitcoin, a lot of what Gitcoin does to get people interested is they have a whole merch marketing department and memes as well. And memes are IP and all that. So it really gets people emotionally connected with what's happening in the developer space. And realizing intellectual property is art, really. So if you're communicating art, then you have to interact with intellectual property. I almost think that it's, at least from my perspective, uncommon for a DAO to not interact with IP in some way, shape, or form. Yeah, I wonder what your thoughts are on that. Like, how many DAOs actually don't have to engage with IP, period? Like, real property maybe, but like, yeah.
I mean, software is copyrightable, right? So a lot of DAOs don't really start as DAOs. They start as development companies that then exit to community or decentralize. So those coders that are making the first draft of the protocol, that are putting together the software that the organization is going to run on, that's copyrightable. And it becomes, under US law, it becomes copyrighted as soon as they write it. You don't need to register under US law. It's a common misperception. You need to register to get statutory damages and some other additional claims. But if you're a writer and once you write that poem, once it's on paper, you got a copyright. Same thing with a coder. Once you type out that script, you have a copyright. So the software is relevant. And then obviously, like any other asset that an organization wants to hold, whether it's cryptocurrency, whether it's physical assets, whether it's real estate, intellectual property is one of the many assets that an organization will like to create and exploit as it builds its organization or its business.
Interesting. So things we create are intellectual property by default.
Are things that are copyrightable. So under the Copyright Act, it's I'm going to be putting the words out of order, but it's whenever you fix a work of authorship in a tangible medium of expression are the important things. So it's that act of fixing your expression into a medium creates a copyright in whatever that expression is.
Okay, so so maybe we should pull back a bit because there's copyright, there's intellectual property. As a plebe, I'm already confused. So what is intellectual property?
So intellectual property so what's property? Let's pull back first.
Oh,
so
nice.
the law recognizes the US, the Anglo-American common law recognizes property, right? This is the right to exclude people from some kind of asset. So if I have a property right in a piece of land, then I have the right to exclude you from it. If I have a property right in this microphone, then I have the right to prevent you from taking this microphone from me. I get to use the microphone, right? Intellectual property is a newer 500 years subset of property that covers non-physical things. So the categories of property that we're all familiar with, you have real estate, so real property, you have chattel, what's called chattel property, which is physical things. And then you have intangible property, of which intellectual property is the most common one. And the big four categories that we talk about when we talk about intellectual property are, some of these are familiar to you, I hope, are patents, copyrights, trademarks, and trade secrets. Trade secrets are kind of the odd man out, but those first three are the big ones. And as opposed to our traditional understanding of property, which exists even absent some kind of specific law granting us this right, in the Anglo-American liberal system, you have property rights under what's called the common law. All IP are creatures of statute. So there's a Copyright Act, there's a Trademark Act, there's a Patent Act, and those define very specifically what your rights are with respect to whatever that statute is describing. So for copyright, that's the expression of ideas. For patents, that's inventions. And for trademarks, that's brands, or marks is what we call them.
Yeah, and I would add that with patent, comparing it to copyright, it's good to understand that concept of idea, because with patent, that's really, you're trying to monopolize the idea, and so that's one of the reasons why patents are so hard to get. Whereas with copyright, it's really just the particular expression of the idea, right? So if you're thinking about, if you're as a coder, you have 1,000 ways to get to the end result, the way you write that code. Well, the end result and the fact that you want that end result, that's the idea. So to get the patent for that, that's pretty difficult, because basically you have to come up with a whole new kind of problem and solution. But with copyright, all you have to do is just express your solution, right? So all you have to do is just write your particular functions, and then you've got that copyright. And so the monopoly is a lot smaller, because it's really, other people just can't say it the same way you've said it. So they can get to the end result and then by saying it in a different kind of way. But that's the key distinction. And with trademark, it's also, that's more about what the consumer recognizes. So if the consumer gets confused, and if they think that they're buying it from one DAO, but they're actually buying it from a different DAO, well, that's when trade comes in. But it's much more from, the user's experience than from the person who made the trademarks perspective.
And monopoly is a great word to use here. I think that actually, I tend to describe them more as intellectual monopolies as opposed to property. I think people get kind of hung up on the property aspect, when really what this is a complete monopoly over a particular idea. So no one else gets to use it unless you allow them to use it, which is, as might become apparent later in this talk, or it might not. I'm an IP lawyer, but I'm kind of an anti-IP guy. But yeah, that's probably the better way to think about it, is monopolies.
Well, it's interesting because part of me wants to say, like, how dare someone monopolize an idea? The other part of me wants to say, well, we've come a pretty far away in our society in 500 years. Perhaps that's because we figured out how to monetize and turn ideas into assets, because then it incentivizes ideas. So there's this tension between, something we don't really like, but something that actually is quite effective.
So the Supreme
it's a
Court
struggle.
has talked a lot about that, and it's a very interesting point that I think gets lost. So a little bit of copyright history that's worth noting is that the term of the copyright when it was the first United States Copyright Act was passed was 28 years, and then you could renew it for another 28, and then it became part of the public domain. So copyright was always kind of understood as this trade-off against the rights of creators and an incentive from the government to creators be like, hey, we want you to make things. We recognize that if you don't have a monopoly and the right to profit from it, you're probably not going to be able to do it professionally. So you'll just have to do it in your spare time. And we're going to have a whole country full of people that are, amateur artists, amateur creators. No one will be able to do it professionally unless they can make a living doing it. So we'll give you this temporary monopoly. But we're recognizing that what we're doing is we're pulling an idea, something that has zero marginal cost to share with people, right? I think maybe the Jefferson quote's apocryphal, but I think the way that he described it is if you have a candle, if I light your candle using my candle, I'm not being deprived of any light, right? So the idea of ideas spreading that way is a natural characteristic of how knowledge and ideas spread. So the public domain was this understanding of this is our shared pool of knowledge from which we're carving a monopoly because we want to incentivize creators. But we know that that's a trade-off. We've always known that that's a trade-off, that we are suffering as a community so that the individual creators can benefit. So hopefully after 28 years or 28 times 256 years, we could have these things in the public domain. Now, over the course of the intervening 200 years, we've seen copyright extend and extend and extend. And now, if I remember correctly, it's 90 years. It's the artist's life plus 90 years before it enters the public domain. So practically speaking, nothing has entered the public domain since the 30s. And a large reason that this has happened is as successful IP industries have emerged in the 20th century, particularly Disney, every time Mickey Mouse came close to entering the public domain, Disney would lobby and get an extension and an extension and an extension. And the last one was in 1998. The Sonny Bono Term Copyright Extension Act was literally just there to extend Mickey Mouse for another 20 years. A whole lot of things happened in 2018 that are probably beyond the scope of this. But I just wanted to paint that picture to illustrate that there's always been this trade-off. And lately we've swung way too far, in my estimation, in favor of protecting and incentivizing large intellectual property holding companies like Disney, as opposed to the public domain. That's my little speech. I'll stop now.
Oh, totally. I totally, I agree with that. And then in our space, though, the developer space, when you have an Apache license or a GNU license, what you're saying is you don't want to participate in that. And so you're basically allowing it to be in public domain from the get-go. And then for something like Mickey Mouse, that's where Creative Commons comes in. So if you've got a Creative Commons 0, it is really then just public domain. And so there are these layer 2, I guess you'd call them, because they're not statute, right? They're secondary organizations that then kind of roll back this Disneyfication that's been happening of that balance. And it makes a lot of sense with what we're building here in Web3 to not have that paradigm that Disney wants, because we don't really care if you write the function this way, that way. If it really matters to be standardized when we go through EIP or something like that, we really just want people to actually spend the time to automate. And we don't want to cause friction by saying, hey, I own that particular expression of automation. We'd rather people copy paste it and then add on more automations.
That was fascinating. That's great. Okay, so I guess power begets power. That's a good takeaway. Mickey Mouse is cute, but beware. That's the second takeaway. Third, individuals can come up with ideas and IP and have IP. it sounds like companies can have ideas and own IP. What if we come up with an idea as a group? What if a DAO comes up with an idea? What is that someone's idea? I mean, how do we grapple with that as DAOs?
Yeah, it's the person who created it, right? So in a DAO context, obviously, if you have like a cooperative of folks working on it, like you all have a bunch of people, working in GitHub, writing software together, it might be hard to parse the final piece of software down by the individual rights. So traditionally, in a corporation, anyone who's worked in tech for a company is probably, as part of their employment letter, signed something called a PIA or a CIA, Confidential Information and Invention Assignment Agreement. That essentially, under the Copyright Act, designates the corporation as the author for whatever is created in the terms of your employment. Obviously, DAOs don't have that. So the question then becomes, who does the right vest in? And right now, there's no real clean answer. We can look to the law of, hacker collectives and cooperatives that design software, but unfortunately, a lot of these organizations didn't really enforce software rights or intellectual property rights, to my knowledge, as against each other. They would often try to enforce against, corporations, or corporations try to enforce against them. Not super familiar off the top of my head with the case law of how all that shakes out, but usually there has to be a legal person that holds the asset. The right vests in someone, because again, intellectual property is really, and in the context of DAOs, in the context of corporations, we only care about IP for two reasons. We care about it so that we can enforce it against someone else. So if we're like, hey, you're stealing my stuff, don't do that. And if they don't stop, then I want the power of the state to come to bear and stop them. Or if I have a business that's valuable and someone wants to buy that right from me, it's an asset that I have. So I want to be able to prove that I have good title to it, so that when I sell it to them and they try to enforce it, the court won't be like, well, turns out you don't really own the thing that you think you own, so there's no lawsuit here. So those are really the only two things that matter. In the context of DAOs, it comes back.
Is there a third, which is defensive?
So in the context of patents or trademarks, you can leverage your patent to defeat someone else's patent claim. So if you already have something that you believe covers the patent claim, or in a trademark, like if somebody tries to register a trademark and you're like, hey, I've been using DAO Denver for the past couple of years, I just haven't gotten around to filing with the trademark office, and someone else tries to file DAO Denver, you can defeat them with that. But generally, so I would, we'll call that 3. We'll give it 3. We'll simplify it. Yeah.
I cut you off though. I'm sorry.
Yeah, I lost the train. Where was I?
Where was he?
Yeah. So you need a person, right? Someone needs to enforce these rights. Someone needs to own this asset. Corporation's a person. Individuals are people. DAOs are... we don't know yet, right? This is one of the reasons why a lot of lawyers are constructing legal wrappers, right? So you might have an LLC that holds the asset, and you might have an agreement as amongst you could have contractual relationships among all the DAO. Like I've seen some DAOs consider terms of service type arrangement that by participating in the DAO, you agree to this constitution. They might, the DAO tokens might represent membership interests in an LLC. That LLC then holds the asset. There's a lot of different ways to do it, but ultimately, and this is the important point, the DAO doesn't hold anything. The DAO uses a legal person, an entity or a human, to hold the asset and then do things with them. And this obviously has its advantages and disadvantages that we can also talk about, but
yeah, I would just add at LexDAO, that's one of the reasons we have CaliDAO. It's to create a person behind it, and using Denver's structure, or not Denver, Delaware. It's crossing my D's there. And then one thing that's interesting too, as well, is if on the litigation side, right? People can think, oh, well, if I don't have a legal person, no one can go after me because it's I'm just like fog or something. But I don't know. It seems to me like looking at past instances of litigation, they'll find a way to connect it with some kind of legal person, right? And so then that might not actually work out for people in DAOs because it might have full liability then. It might be just considered a straight up partnership, right? So you kind of like, you hopefully can give a little bit more advice on this being an actual attorney, but or comments at least. But yeah, to me it seems kind of sketchy to go, oh well, since it's not a legal person, I can infringe copyright. I can throw up music NFTs owned by different artists, and RIA can't go after me. It kind of seems like that's just asking for trouble, where it seems like, you know, in the short run, it's a solution, but in the long run, it's just going to lead to actual litigation, full-on litigation with big legal costs. But yeah, do you have?
Yeah, absolutely. So we're distinguishing now between me having intellectual property that I can enforce against other people, and me infringing someone else's intellectual property under the cover or non-cover of a DAO in the fog, as you said. And if there's one thing I learned early in my career, I was helping folks that were being targeted by the recording industry and the Motion Picture Association that were using BitTorrent to as part of a swarm to
Pirate?
Well, you know, pirate only applies if the work in question is copyrighted. You can access public domain things and non-copyrighted issues. But the mechanism that they used here was, let's say you use Comcast as your internet service provider. So the recording industry would find that an IP address assigned by Comcast was in this swarm, right? And then they couldn't necessarily tag that to your computer. So what they would do is they would issue a subpoena to Comcast demanding that they turn over that information. And so that's the area where you would fight back against that. And I only bring that up by way of illustrating that these guys will find you. They have their mechanisms. They're willing to use, go through a lot of processes to find you. And, I've gone to a couple of crypto conferences. I met a lot of you guys. Your OPSEC is not good. You have bad OPSEC. They will find you. So infringement in the context of a DAO is particularly bad because they can usually point to somebody that is doing the infringing, particularly if you're talking about in a Discord. So it's the questions of who owns IP is much murkier and more interesting, but who's infringing is a much simpler question.
I have so many follow-on questions, but my questions don't matter. Your questions matter. So why don't we move to some questions from the audience?
I think we have time for one question. I wouldn't want you guys to come here, have these guys here.
I'm verbose. It's my bad.
Yeah, and not get some free, not legal advice. Go ahead.
Just the lack of patents in this industry, is it a sign of immaturity or is it a sign of cultural division? Are you guys seeing people doing patents? What do patents protect the members of the DAO? You know what I mean?
So there's a lack of patents in the blockchain space. Is that a sign of maturity or immaturity?
Well, I mean, I actually do have a patent in the space, so I'm kind of unusual with that. Yeah, I think part of it is a sign of philosophy. I really actually, especially because I do work with Creative Commons quite a bit, and I personally err on the side of public domain and spreading light. I kind of like it that people are kind of like, they look at my patent and go, what the hell are you doing? Like, this isn't what we're up to. And so from my perspective of going through the patent process, I also know the knowledge that the patent agent put in there and the ability to put it into a larger context and just make the object much more meaningful. So I really cherish the value that is coming in, but I also recognize that it's an antiquated system that needs to be much more fluid. And so that's one thing I personally hope with my patent is that I can eventually carry it through a DAO and have it be, more public domain than patents have been so far. Where if we look at the history of patents, they went towards the troll side of things from when they initially started. I mean, when I went to my agent, he just was like, well, there's never a lone inventor that comes in with a cool patent anymore. Like, that's just like, anyway, it was just surprised. Like, it was just legitimately surprised because it's just giant corporations that do it. Endangered species. That's what it was. So yeah, I don't know if it's a lack of maturity. I really do think it's just a philosophy that just doesn't jive well. And I would like a better harmony because I do see value on both ends. But so I maybe in that sense it is maturity, or pardon me, an issue with maturity, because we can maybe get to that point where we have it's not trolling when you have a patent, but you also get that amazing knowledge that the Library of Congress has. And so, like, I didn't even know my thing was a von Neumann architecture, and I got to learn so much about von Neumann through it. And that's just, all of us are working, and when we're coding, we're working with what von Neumann. It's not just Turing; it's both those guys. And so, I'm really appreciative of that.
Yeah, I think it's definitely a cultural thing. That's a huge issue, especially like we've seen how projects that grant copyright to their NFT holders versus ones that try to enforce it, like Larva Labs getting a lot of shit. But when it comes to patents, it's expensive. It is so expensive to get a patent and to go through that process. And there was a major update to the patent law passed during the Obama administration called the America Invents Act, which introduced this concept of inter partes review, where people could sue during the patent review process, which adds the cost of litigation into the patent process as well. So now it's essentially only accessible to large corporations, and they haven't really started making moves in this space. But the other element that I think is going to fluster them if they try is, let's say that you're trying to get a patent in a blockchain protocol, and you upload it, you upload your smart contract or you upload your protocol onto the internet, and someone sues you for infringement. Would you take it down? Like, do they have to go after every single node operator? Like what do they do, right? So usually when we're thinking about intellectual property or copyright, we're thinking a lot more about art. It touches on software. There are software patents, but enforcing against like art, like telling somebody like, hey, like disable this link to your JPEG because it's infringing, is a different question than take down your software protocol.
It's a question of enforceability, basically.
Exactly.
So before we let you guys go, our next panel, which we are going to ask our panelists to come up and get ready for their panel backstage, but it's on digital identity. And with that topic, obviously the blockchain introduces a whole different type of identity, and potentially one that's not doxed, and anonymous one. Is there any precedent that you know of in copyright or patent law or patent cases where the inventor was anonymous or in a pseudonymous, perhaps?
Yeah, there's a lot, like, the easy example would be like street artists, right? So Banksy, right? And courts have, because artists have a long tradition of pen names and stage names, right? There is precedent allowing people to sign contracts and to sue under their stage names. So if you've developed this identity, and if the court in some kind of, if your lawyer petitions the court and says, hey, they have this strong vested interest in their brand, they're identified as Banksy, a big portion of the value of their brand is that they're anonymous, but we can prove to you, judge, in a side panel without revealing any information, writ large, that this person is a legal person who, owns this thing, and we can provide all the proof. Then, yeah, there's precedent for artists, proceeding in their cases and acting as legal entities under their pseudonymous identities or anonymous identities.
And then with patents, because it's pretty much only corporations that can patent at this point, you can kind of think of a corporation as a way to make things anonymous, right? Yeah. This is a giant organization, and so the inventor in the corporation, you don't know who that person is. Someone in 3M, right? Like, that's it. But who is 3M? 3M is an actual human being. And so it really is, patents are actually much more anonymous, and that's the pressure. There's the Edison type individuals aren't really a thing.
Got it. Is the next panel ready, or do we have time for one more question? Great. So let's end on a forward-thinking note. You brought up the example of file sharing and enforceability. How do you enforce, patent protection? You can't take down all the nodes. So we've talked a lot about how the existing paradigm of intellectual property applies to blockchain and DAOs. Do you see, looking forward, do you think that the impracticality of that and the unenforceability of that means that actually DAOs and the way things work in a decentralized world will change the paradigm of intellectual property? And if so, how?
Well, I mean, I think it already is changing it. Yeah. And I mean, one of the things is just people on their own volition deciding to do that second layer licensing, right? So they don't even, it doesn't even start that way. They don't even try to use the straight up statutory method. But what are your thoughts?
Yeah, this is how we win. I think NFTs are superior technology to copyright. And going back to what I said earlier about trade-offs, I think intellectual property is best thought of as a social technology, right? It's something we've agreed to do as a society that violates the normal laws of physics, meaning ideas are zero marginal cost. I just speak them and now they're in your head, right? I don't lose my idea by giving it to you, right? So what we've done is we've imposed this social technology that increases the marginal cost and puts that tax revenue essentially into the hands of creators. NFTs as a vehicle, as a container for assets, allow us to not do that. Creators can get compensated by selling NFTs or by programming their intellectual property into an asset, and then other people viewing it or interacting with it can do that freely. I can, right click and save all the JPEGs I want. But what we've clearly seen is, despite the fact that that's true, NFTs still have tremendous value. And I think as people start building out broader use cases in NFTs, not just like, hey, this is a digital piece of art, but hey, this is, a membership into an exclusive club of, early supporters of this artist that get, access to exclusive galleries that, XYZ, like, there are other ways that don't involve being like, hey, dudes with guns, if this guy doesn't pay me for my, or take down what he's doing, I want you to force him, right? That social technology no longer seems necessary. And I think as more and more artists opt out of that system, using tools like Creative Commons, using NFTs, we will see, the beginnings, I think, of a revolution, especially because it'll feel increasingly bad to sue people to enforce your IP, right? It's going to be a dick move. It's already kind of a dick move, but it's going to be increasingly so. That'll affect the brand of the artist, the brands of the company. They're going to be bad players in the space. And because they don't need to now, because they can make money in this alternative way, we don't need to accept the same trade-offs as before. So I think we're at the beginning of a sea change when it comes to IP rights.
I would just like to add to getting a little bit more esoteric. There's things called compulsory licenses in the music industry. So like my side of the music industry is a music publisher, and that's songwriters and all that. But then there's labels, and that's the artists. So the people actually record and the people you listen to, and the people that are celebrities that have major fans. And what happened historically is that labels gained so much power that they put pressure in, kind of like Sonny Bono stuff, to have compulsory licenses for songwriters and all that. So when Neil Young took his music off of Spotify, it's not like you can't listen to Neil Young's music anymore on Spotify. You just can't listen to his music recorded by him, because he's also a songwriter. So you can still listen to the songwriter side of Neil Young on Spotify, just not the artist part of Neil Young. And so even though that was, the label Strong Army Publishers in the historical context, hopefully we can think about compulsory licenses going forward with what the NFT context. And so we can just have more of that, where royalties happen, but there's not that monopoly that occurs. So people still get paid. People still have the ability to be artists for a living, but they also don't get to say, rage quit. So rage quitting is pretty good too. So.
Great. Yet another way blockchain is driving change. Thank you for sharing your knowledge and expertise with us today. Hopefully it's not protected by IP. We really appreciate it.
Thank you. And thanks, Mark, for such amazing moderation.